Very good evening to all of you. I welcome you all to the ICAN initiative, the Hindu and Indian Express analysis. Before we start with the topics of the day, I wanted to talk about a few things. Some of you in the comment section are, if you're new to this platform, you're asking us to give the links of the videos where I have discussed some topic previously. So we'll definitely try to do that shortly. And I would also request you to go back to the previous videos of ICAN and start watching from 1st of April. Because even if you're preparing for next year, that is 2021, this is extremely important for you. And for prelims, 1.5 years current affairs is very important, and same goes for mains also. So 1.5 years current affairs for mains, at least that much current affairs is very important for you. So before the pressure starts mounting on you from next year, now itself finish off all the backlogs, go back to April, start watching all those videos and make notes systematically. And if you are really confused about how to make notes from ICAN, if you go to the playlist, I have made a separate video on how to make notes from ICAN and how to revise and how to utilize it to the maximum extent. So you can go through that video and you will get an idea on how to make notes from ICAN. So that will be very helpful to you, and you will be able to complete the backlog, make notes and also revise properly. So be very systematic and organized in your preparation. Only then, and very consistent also, only then things will fall in place and you will see your name in the list. And one more thing that I wanted to tell is, because these days the news items is mostly related to either the COVID pandemic or the India-China relations. So we don't have much of a diversified news, and ICAN videos are short. So let us use this time to resolve as many doubts as you may have. So you can post in the comment section, come out with as many doubts as possible about any doubt that is related to the preparation about this exam, whatever it is, come out with as many doubts as possible. I'll try to take them and in bits and pieces distributed over the week. I'll try to resolve your doubts, because the length of the videos are either way, the content is either way now short because of the kind of articles or editorials that are there in the newspaper. So we can make use of this time to resolve your doubts. So come out with doubts and get it resolved in the beginning of your preparation itself if you're preparing for 2021. And don't wait for things to until it's the last moment. So start with the right step and go prepare in a systematic manner. So do ask your doubts. We'll plan to clarify it over the spread over the week. So now let's start with the topics, which is the telecom sector. So telecom sector as an important sector of the economy comes under your GS paper 3. So this particular editorial dealt in detail about the various issues that the telecom sector is facing. So let's explore these various issues. In fact, in one of the previous ICAN videos, we had understood the concept of aggregated gross revenue, or AGR. So this AGR is nothing but the license fee which the telecom operators have to pay to the Department of Telecom. So a lot of these telecom operators owe so much to the Department of Telecom, and because of the poor financial health of the telecom operators, they were unable to pay the AGRs to the Department of Telecom. And also because of the rising debt of the telecom industry and their inability to pay the AGR to the Department of Telecom, this issue was taken before the Supreme Court, where the Supreme Court has gave a judgment that a time period of 20 years need to be given to the telecom operators for them to settle their AGR dues. So later on, it was decided by the government to give a window of 10 years for these telecom operators to settle the AGR dues. So now in this article, we will explore in detail the problems faced by the telecom sector. The first problem is the problem of huge debt. So these telecom operators are running a huge debt. So just now we were talking about the AGR, the aggregate gross revenue which the telecom operators have to pay to the Department of Telecom, which is nothing but the license fee. So this license fee itself of all the telecom operators, they amount to 1.47 lakh crore, which these telecom operators have to pay to the Department of Telecom. This is the due that is there. So this much amount of payment is due to be paid to the Department of Telecom. So this AGR dues itself indicates a very huge debt. Apart from this, even if you take the independent telecom operators, they also have a huge liability. The VI, that is Vodafone Idea, for instance, has a liability of 54,000 crore. And in fact, in the financial year 2020, VI, Vodafone India, has reported a net loss of nearly 74,000 crore. So from this you can see how poor the financial health of these telecom operators are. So the first issue is the huge debt burden that these telecom operators are under. And because of this huge debt, it is also affecting the banking sector, because the banks have given a lot of loans to the telecom industries and now they are facing a lot of non-performing assets problem. So the next issue is the AGR issue, which I have just explained. And apart from Vodafone, even Airtel owes nearly 26,000 crore that it has to pay as license fee or the AGR to Department of Telecom. So every major player in the telecom sector has a lot of AGR dues which are to be settled with the Department of Telecom. And given their very poor financial health, it is very difficult and extremely difficult for them to cover up these dues in the coming few years. So this AGR issue is the second issue, which is further bleeding the already poor telecom firms which are already in poor financial health. The third important issue is the tariff pricing. India is said to be one of the lowest priced countries in the world, where the tariffs are extremely low. So the next question is, so then what we must do is to raise the tariffs. But raising the tariffs doesn't happen so easily, because they operate in a competitive environment. The tariffs offered by one of the players, say Jio, is very low. So in such a case, the other telecom operators cannot increase their tariffs to become so high that it becomes uncompetitive. So tariff pricing has also become an issue. In fact, looking at the dues that the other major players have with the Department of Telecom, then Airtel requires to raise its revenue by at least 10%, and Vodafone Idea needs to raise its revenue by at least 25%, 27%, if these two have to offset their AGR dues. But however, there was already one round of tariff increase that has happened, and now to go for another round of tariff increase is not possible, given a very competitive environment where the lowest pricing products are the most attractive for the consumers. The fourth important issue is the entry barriers. So in this case, the idea that resonates among the policymakers today is that there needs to be a healthy competition in the telecom sector. In order to have a healthy competition, now there are just 3-4 major players. So we need to induct more players in the telecom sector for a healthy competition to happen. But for that to happen, these entry barriers need to be removed. So when we talk of entry barriers, it could be the spectrum acquisition costs, which are very high, and that is actually a disincentive for any new firms that are looking to make their place in the telecom sector. Second, they also have to pay this license fee to the Department of Telecom, which is nothing but the AGR. They will also have to set up the various infrastructure that is required to operate in the telecom sector. On top of all this, the policy is also not very certain and stable. So the policy uncertainty is also there, along with all these barriers at the entry level. Because of these barriers, it is very difficult for the new firms to enter into the competition and dismantle the monopolistic situation that is there in the telecom sector today. So these entry barriers are preventing the growth of new firms in the telecom sector and thereby a healthy competition. The next issue is monopoly. 90% of the market share in the telecom sector, in fact the 90% of the subscriber base is taken up by Jio, Airtel and then Vodafone Idea. So all of these three together form 90% of the subscriber base, and after this comes the public sector, which is the BSNL. So therefore BSNL, which is the public sector, also has a very irrelevant or very small portion of the market or the subscriber base, and majority is taken up by these three firms. Out of these three, we already understood how much dues the Airtel and Vodafone Idea have now to the Department of Telecom, how much huge debts they are in. So in this case, it obviously becomes that Jio has now having kind of a monopoly in the telecom sector. So such monopoly is not good for in any sector, because what we need for any sector is a healthy competition, so that these monopolistic tendencies are not there, because such monopolistic tendencies could then degenerate into something that is against the interest of the consumers. So for a healthy market to operate, we should not have monopolistic tendencies, and in this case, just these three operators are now having more than 90% of the subscriber base, of which Jio is now is like the monopoly in the telecom sector. And the last issue is the falling network quality. So when these firms are already under such huge debts and they owe a lot to the Department of Telecom in the future as well, and their financial health is very bad, then how can we expect them to invest in the expansion of their network capacity and improving the network quality? So now it is suggested that the network quality is also deteriorating by almost 20%. So the network quality is also now falling because of the inability of these debt-ridden telecom sector firms, which are unable to now invest in their expansion of their infrastructure and their network capacity. So therefore, the network quality is also now falling at 20%. So these are the important 6 issues that the telecom sector is facing. So in such a case, what this editorial says is, if we need to enable these telecom firms to improve and invest in their infrastructure expansion and improve the network quality, then we need to give cash into their hands. First of all, they are already debt ridden and they are already in poor financial health, in which case one very good way of ensuring that they have some money left to invest in infrastructure expansion is by reducing the impact of what these AGR dues have on them. So in this situation, this editorial gives a very good recommendation that instead of the license fee or the AGR, there can be what is called as a nominal administrative fee, which could be charged on these telecom sector instead of the license fee. So this is already in practice in many other countries, and even the National Digital Communication Policy of 2018 has recommended that such charges should be rationalized, and we need to keep more cash with the telecom sector firms so that they have some money left with them to be able to invest in the qualitative expansion of the infrastructure and to improve the network quality. So instead of license fee or AGR, we can have an administrative fee that these telecom sector firms pay to the Department of Telecom, and this administrative fee should be very nominal. Thereby we'll be putting more cash into the hands of the telecom sector firms, which will then be able to invest in network capacity expansion. So this was about this article. Now we'll move on to the next topic. The next topic is related to judiciary and the 3 pillars of the state: executive, legislature and judiciary. Anything related to them will come under your GS syllabus too. So this is related to the contempt of court issue. Contempt of court issue we have already discussed in great detail before. So what is contempt of court, and what is civil contempt, what is criminal contempt, the various judgments, why it should be there, why it should not be there, all these detailed analysis we have already done before when the Prashant Bhushan's contempt of court example was doing rounds in the news. So now this is another example that is related to contempt of court, which you should know, which you can quote in your answers. So this example is where a High Court judge on Madras has written to the Chief Justice of the Madras High Court that Surya, who is a popular actor in Tamil Nadu, he should be charged under the contempt of court provisions should be invoked against him. So what did Surya tell? Surya basically remarked on the conduct of the NEET exam for entrance to the medical courses. So Surya said that the court has become so much fearful of the corona pandemic that it is conducting its proceedings virtually. So the court is doing the virtual through video conferencing. It is dispensing justice because of the fear of pandemic, but it is ordering children to go out and write an exam without fear. So this is what Surya said, and the judge of the Madras High Court said that the actor, by saying like this, has actually questioned the integrity and the devotion of the judges of the High Court. So, therefore, this is also going to undermine the public trust in the judiciary, and therefore, contempt provisions must be invoked against Surya. So, this is what the judge of the Madras High Court has written to the Chief Justice of the Madras High Court. And also, what is being argued is that what Surya has remarked is an obvious fact that the court has been doing virtual hearings since the start of the pandemic in the country, but it is now allowed more than 500,000 students to go out there and then write the exam, which could be very riskier for them. So this was the order by the court itself that the NEET student should write the exam. So this shows, even though when Surya was trying to state something that was an obvious fact, this has been taken by the court as targeting or questioning the integrity and devotion of the judges, and his statement undermining the public trust in the judiciary. So this example you can quote when you are writing about contempt of court issue. Now we'll move on to the next topic. This is the last topic for the day, which is related to the Unlawful Activities Prevention Act. So this comes under your security issues as a part of your GS3 syllabus. The reason Unlawful Activities Prevention Act is in news is because in the recent past, this law has been invoked multiple times, and therefore this act per se becomes very important, and you may be asked a question on analysis of this act. So why this is in news recently in this particular editorial is because one of the JNU student, Umar Khalid, has now been taken into custody by the police over the fact that he conspired in starting the anti-CAA protests that happened in Delhi in February, and also the consequent communal riots. So the police say that this was a conspiracy of Umar Khalid, and he even provoked the minorities to come out on the roads and make a propaganda that the minorities are being persecuted in India. And during the same time, the United States President Donald Trump was also to visit India. So the police say that this was a conspiracy to completely make this propaganda while the president is making a visit to India, so as to create a very bad image about India. So under all these, and also the police say that they have an evidence that Umar Khalid executed this whole conspiracy and the plan, because they have been able to get some WhatsApp chats that indicate the same. So now in this backdrop, we will analyze the Unlawful Activities Prevention Act, and whatever issues have been raised under this article we will be discussing. First is Unlawful Activities Prevention Act was first enacted in the year 1967. So it says prevention of what kind of activities? It is the unlawful activities which have to be prevented, and they may be committed either by individuals or they may be committed by associations. So if they are dealing with any terrorist activities, then those kind of activities, if they are done by individuals or associations, that needs to be prevented, and for this the UAPA was enacted in the year 1967. After this, several amendments have been done to UAPA, and most recently in 2019 an amendment was done. So every amendment that was done to UAPA has made it even more stringent compared to its previous version. For instance, the 2019 amendment, it says that even an individual could be designated as a terrorist. The earlier version, only organizations could be designated as a terrorist organization, but an individual could not be designated as a terrorist. But the 2019 amendment made it possible to designate even an individual as a terrorist. And also under the UAPA Act, we have special courts which will try all these unlawful activities or terrorist related activities. Whoever is charged against carrying out all these activities, special courts have been set up to try these UAPA cases. So this is a basic about UAPA. Now let's understand what this act means by saying the unlawful activities. The act defines unlawful activities. So these unlawful activities could be in any form. That is, it could somebody could just speak out something, or it could be in the form of written words, or it could be sometimes like a sign or even a visible representation. So these are the various forms in which the unlawful activities could be carried out. Second is it must be related to if the activity is trying to bring out secession of any part of India, or which is inciting secession. So if it is inciting anyone towards a secession from India, that will be declared as unlawful activity. Or any other activity that disrupts or it intends to disrupt the sovereignty and territorial integrity of India, then that is unlawful activity. And the third is any activity which causes or it intends to cause disaffection against India, then that is considered as unlawful activity. So one is the different forms. In all these forms, unlawful activities can happen. Then it must ask for secession of the people from India. Second, it must intend to challenge the sovereignty and territorial integrity of India, and it must also be wanting or it arousing disaffection against India among the people. So all of these kinds of activities will fall under the definition of unlawful activities. Now let us analyze the 4 important issues that have been raised under this in this article related to the UAPA. The first issue is that this act has been very much misused. So even before the UAPA was enacted, there were other earlier versions which is TADA and POTA Act. So later on, UAPA was enacted by saying that this is less stringent and less stringent compared to the TADA and POTA Act, which have already now lapsed. So, but however, in the recent times, UAPA has been used or rather misused, and it has been invoked against various activists, even journalists. Journalists have been targeted. So, like that, recently UAPA has been invoked against activists who are involved in the Bhima Koregaon case. It has been invoked against journalists in Kashmir, against some of the members of Pinjra Tod, against some students of Jamia Millia. So like that, now the same UAPA Act has been invoked against Umar Khalid. So like that, even against student activists and journalists, this act has been invoked time and again. So we can say that this act has been misused. This is the first issue. The second is the ambiguous nature of the act. So in the previous slide, we were discussing about the definition of unlawful activity. In that, one prominent thing is any activity that tries to generate a feeling of disaffection against India. It also comes under the definition of unlawful activity. But what is disaffection is not defined in the entire act. So there are some terms which are included in the definition of unlawful activities which has not been defined in the act. This makes the act very ambiguous, and what is disaffection is subject to multiple interpretations, liberal or very strict interpretations. So anything could be targeted or anything could be interpreted as disaffection against India. So that has made the act very ambiguous also. This is the second important issue. The third is the issue related to bail. Once somebody is charged under the UAPA, then it is a very rare case to get bail for that person. In fact, the courts also usually refuse bail to such people if they consider that prima facie this may be a true case. And also in such cases, the accused cannot even seek anticipatory bail. And in such cases, the period of investigation can also be extended to 180 days from just 90 days by requesting the public prosecutors. So which means that the person who is charged under the UAPA will have very rare chances of getting bail. So this is another issue. Usually getting a bail is the right and which should be the norm in cases whenever a person is jailed. But however, under UAPA, it is very difficult for the person who has been charged under this act to get bail. The fourth issue is related to the public custody. In UAPA cases, the public custody, which is usually for 15 days in all the ordinary criminal cases, this can be extended to 30 days. So more number of days spent in the police custody means more time wherein the person who has been arrested could be tortured in the custody. So more duration in the public custody means torture of the person who has been incarcerated. So this again extension of the public custody can amount to torture of the person and trying to extract forcibly some confession out of the person. So these chances are there, which will again amount to misuse of this act. So these are the 4 important issues that has been highlighted in this editorial related to UAPA. So basically we should know when this act was promulgated, what is it, against whom, unlawful activities carried out by individuals or organizations, and then you have to know what is the definition of unlawful activity and some of the important issues related to it. So that is all. These were the other articles that were not important. Venus we discussed yesterday itself, about the presence of phosphine gas. Parliament and its panels, it is saying that the standing committees of the parliament, we need to relook for the time for which they are constituted, which is again very specific and is not relevant for your exam. Then question and answer is about the question hour, which is now being removed from the parliament session that is happening. So similarly, all of these again were not relevant from your point of view of yeah. So that's it for today. Thank you.